So I'm done. And with those words, the suspended Public Protector Busisiwe Mkhwebane's legal team, led by Advocate Dali Mpofu, exited their representation of her. Yesterday, Mpofu presented Mkhwebane's application for the Section 194 committee that's inquiring about her fitness to hold office to adjourn indefinitely pending another court case. The committee rejected the application and thus triggered the exit of Mpofu, who said that was as far as his mandate goes. Legal analyst Mpumelelo Zikalala joins us now to examine the chain of events and its significance for Advocate Mkhwebane. Good evening to you and welcome. So it was before the committee that he made that announcement. That's it. What it means is we're not able to take part in further legal activities which would involve anything beyond this application as indicated, because to do so would acquiesce in participation of this committee as it is currently constituted. It's completely illegal. And then he went on to say good luck and so on. But the question then becomes, we'll get to Mkhwebane's reaction in just a moment, but let's start here. Is this a delay tactic or a legitimate protest against the process?
It's a difficult one to analyze, but you must then look at the process of saying, you may have a legal practitioner who was frustrated by this particular process to such an extent that he felt that he has done all he could have done to protect the legal interest of his clients. And the only way in which he could resolve the matter was to say, please get another legal representative to represent you in this particular matter. I feel that I've done all that I can to protect your legal interest. So be it, take it as if I failed, or take it as if I failed to convince the powers that be that they should allow this particular postponement. But when it comes to me and my capabilities, I do not believe that I'm in a position to render my legal services to you or to the best of my abilities. So the fact that it is Advocate Dali Mpofu that said the mandate has not been withdrawn by my client, but it is me who is saying I'm withdrawing from this particular matter, it simply means that he went on an introspection process and looked at it from his point of view and said, I can no longer do this anymore, either because the practicalities of it are way too much for me, or there are instances in which I've become too involved in this particular matter. I've now become subjective instead of being objective and simply supplying my legal prescripts and legal experience. So let me withdraw and allow another individual to then come in. So I think I was basically saying, I've done all I could.
Yeah.
I'm withdrawing from this particular matter. Please get someone else to continue.
Although cryptically, he did say, and good luck, we'll see you again, maybe, or maybe not. But let's go then to what Mkhwebane said in reaction to this. They didn't even say they're terminating. I must find out from them, are they willing to proceed with me? And then, chairperson, I will have to start afresh and get a new legal team. Sounds like she's at a loss, and this is a decision she was not anticipating.
That's a puzzling one. At least if you're going to withdraw and representing your client, the first person you should contact or the first person that should know about it is your actual client. They are the ones who are giving you the instructions, and you are the ones that you are accountable to them. So if you can no longer continue with this particular process, you must then go back to them and say, I've done all I could. I think that another legal practitioner could do a job better. Can you please let me go and allow someone else to then come in? It does seem to be a spur of the moment type of decision which was taken. Maybe purely out of frustration or through a process in which Advocate Dali Mpofu believed was not being just, so he could not participate any further in it. However, I do think on that part, we must find fault in him and say, you should have at least started with your client, you should have at least started with your instruction attorneys and inform them that this is how you feel, and a proper recusal, a proper withdrawal application would have to be lodged so that the committee is well vested as to what's the reasons for the withdrawal, not for the client to find out while you are making that application or informing the committee that you are no longer willing to take part in the committee moving forward.
Well, would you say, I mean, bluntly put, that he's abdicated his legal duty?
I would say to a certain extent, yes. The mere fact that your client doesn't even know what is happening, they only find out while they are sitting within the back benches and hears it for the first time when you are withdrawing, certainly should be puzzling. Just imagine the type of shock that the public protector went through to hear for the first time that one person was legally representing you, protecting your illegal interest in these crucial proceedings, has now decided to withdraw without informing you. And the only time in which you are hearing it is at that particular moment in time. You don't even know the reasons of what's going to happen. And yet on the next day, the matter is expected to proceed, which is why today the public protector came and represented herself, something in which she was always fighting about and saying, I need legal representation in this particular matter. Even the apex court agreed with her. So at the end of the day, it was a bit puzzling, and I'm sure she must have received a shock of her life to simply learn on that time that she no longer has a legal person who's going to represent her in this particular matter. It's not a conduct which is becoming of a legal practitioner, and I'm certainly that a few other individuals would agree with me that it should be a conduct which is frowned upon.
Well, similarly, against the backdrop of everything that's happening, cynically, we might come back to the question of could this be part of a ploy? But we'll hold on to that for a second. If she fails to convince them to come back, she needs to find a legal team and get them up to speed. Mm-hmm. Where does this leave the process, and what are the likely delays now going to be?
They're going to be long delays. Remember, when a new person comes in, they still need to go through the prescripts. They can't rely on what has been stated in the media. They have to read the various documents that have exchanged, various communications that have taken place from one party to another, go through on a page-by-page basis on all the evidence that has been presented. Now, the question or the one important thing to achieve by doing that is, do you want to recall any of the witnesses so that you can pose your own questions in cross-examination and make sure that the legal strategy that you want to adopt is the appropriate one? The minute you do that, it basically means that you can end up calling nearly all the individuals that have been called earlier to come back and provide evidence. Certainly, that's going to extend the amount of time that these proceedings are going to take place. You may call for further or clarification or further evidence or further particulars pertaining to the matter. That's going to extend the duration of this particular committee. Now, I'm sure that this committee has been given specific timelines in which they have to respond by. And by that, it means that particular timeline has to be extended, and they're not going to meet the deadline that they've set themselves.
So doesn't it in a way achieve, what they were there for in the first place? They wanted the adjournment on the 3 recusals. She's been fighting the process in terms of both the composition of the committee and the needing of more time. This gives her that, even albeit in a roundabout way. And as I mentioned, that quote from Dali Mpofu, leaving that door open, see you, what did he say? See you later, good luck, see you again, maybe or maybe not. I mean, there's a fair amount of cryptic messaging in there. Or are we reading too much into the scriptures, Mpumelelo?
There may be a bit of information that you should be getting. And the information is, we need a bit of time to go to court to review your decision not to recuse yourself. We cannot continue with that while the proceedings are taking place. So let's get the weekend, for example, to start drafting our papers. And once the matter has been lodged at court, one of the urgent relief that you are going to seek is that for the proceedings to stop up until this issue of biasness has been resolved. Now, that ends up buying her time in order for her to stay a bit longer in time for her to deal all the processes that are there and maybe to answer all the questions that they might have held earlier. So in a way, maybe one would call it a blessing in disguise for Advocate Mkhwebane. She needed time. Yes, she has received time in most unconventional manner and in a manner which shouldn't be really encouraged at the end of the day. There's no legal practitioner that should leave their client in hot water such as these ones. You should make sure that you protect the legal interests of your client until the end. And if you feel that you can't do that anymore, there are appropriate ways and means of doing it. Firstly, informing the actual client that I can no longer represent you, please find someone else, but not to leave them in a loop like Advocate Dali Mpofu has done.
Well, to quote Alice, curiouser and curiouser, and we'll wait to see what happens next. And Mpumelelo, thank you very much for talking to us and for sharing your expert analysis with us. It was Mpumelelo Zikalala.